Okay, folks, greetings. Thanks for joining us on this webinar session. My name is Jim Labeau, and NERCA has asked me to come on and kind of give you some tips and advice for handling an OSHA inspection if, God forbid, you do get visited by OSHA. The reason they've asked me to come on is I've been practicing OSHA law for about 16, 17 years, and I've handled OSHA cases in Maine and all the way out to Guam and many points in between. And what I've learned over the years is the better prepared you are when they show up, the better off you're going to be to minimize your downstream liability. And that's not just avoiding OSHA citations, but that's, insurance comp claims, personal liability, you name it, going to jail even. I've got a lot of cases that involved a fatality that was alleged to be the byproduct of a willful violation of the Occupational Safety and Health Act. And gosh, what happens when that happens? Well, the Department of Justice comes in and runs a criminal investigation. So it runs the gamut as to the types of liability that you may face, and the better off and better prepared you are, the better off you're going to be in dealing with what comes with an OSHA inspection. Keep in mind that most OSHA inspection files, once they're closed, are actually open to the public through a Freedom of Information Act. So there's all kinds of things you want to be thinking about, and that's why you're here. You're here to be prepared, because being prepared is better than half the battle. So, but what I'm not going to do is I'm not going to teach you how to avoid your responsibilities and avoid your obligations under the Occupational Safety and Health Act. We're not looking to try and skirt your obligations. We're just trying to inform you of your rights, inform you of what powers that OSHA does have, and talk about a few war stories. Well, let's face it, the history of industry in this country has not been a high priority, and safety was not a high priority for many, many decades. And so it made sense ultimately for Nixon to sign into law the Occupational Safety and Health Act. The statistics were staggering, and something needed to be done because people were not making it home to their families. People workers were living with lifelong disabling injuries and things like that. So President Nixon signed into law the OSHA Act to try and prevent workplace safety accidents. And because this attitude of, hey, that's what happens in the field. You get hurt or you get killed. Hey, that's business. I'm reminded of the film Blazing Saddles, where the fastest gun in the world is the Waco Kid, and the Waco Kid says, "I've killed more men than Cecil B. DeMille." Well, Cecil B. DeMille was a big movie producer who made these big epic films and actually killed people, not only in the film, make believe, but in real life. And that the attitude was, that's just showbiz. So that kind of attitude in industry and in construction had to change. So that's why the long-awaited Occupational Safety and Health Act was signed into law, to kind of do away with this attitude that safety is not an option, and it ought to be a priority. Yet some folks don't quite still get the message. I'm glad there's a ton of booze in the background for this guy. These folks, I'm sure you've seen some of these photos floating around there on the web. But, so some folks just kind of don't get it. I think I've been to actually this facility. It's in Oklahoma. Bottom line is we need to work safely. I don't know what this guy's thinking. We need to work safely. We need to take the OSHA Act for what it is. It's something that we all need to follow in order to protect our workers, because we're all going to be better off if we do. Now, OSHA is going to show up. They're going to show up, and it's going to be a time when you least expect it or you don't want them there. I've had fatality after fatality where I don't get called until a day or two later, and the employer who's had to deal with the tragedy is talking with OSHA and talking with the cops, and I ask them, what did you say? And they were in shock when they were interviewed. They don't remember. They don't remember. I had a landscaping company up in Maine, large landscaping company, who had a skid steer come down on the head of one of their workers and decapitated the worker. It literally just crushed his head, and it was awful. And when I asked the owner of the company, what did you say? He had no idea. So I had to go talk with the OSHA compliance officer afterwards to find out what he said. And thankfully he told me. And it wasn't very good. He basically took the blame for this, what ended up being a freak accident. And ultimately we cooperated fully and headed OSHA off at the pass, and they never got issued citations. But I had to unwind what was said in the shock interview that followed during that fatality. And so that's just to highlight the fact that if you're not prepared up front, things are going to come at you awfully quickly. And OSHA's got a job to do. And unfortunately, the enforcement arm of OSHA is really not there to help. If they say they're there to help, that's not true. They're there to build a case against you. And so sometimes they'll show up to see if you're doing what you agreed to do after a settlement agreement. And you need to be prepared to say yes, and hopefully that's true. Like I said earlier, and I'm going to repeat myself through this presentation in order to try and run home the bigger pieces of the most important pieces of the presentation, because the bottom line is we don't want to increase our liability, and we don't want to disrupt our job site any more than we have to. Keep in mind criminal penalties. I had an explosion case for a manufacturer who manufactured smokeless gunpowder. It's the powder that you would use if you went muzzle loading, if you're a muzzle loader. And he was making this cutting edge powder in New Hampshire, and he decided, hey, I'm going to go to SHOT Show in Vegas. You two guys, keep going, keep making the powder. And the place exploded, killing both employees. And I was able to convince OSHA to let the company walk. Don't go after the owner personally. Don't go after the owner criminally. And they agreed to all of that. But what the company, what the owner didn't realize, I don't think anybody realized at the time, is that the local prosecutor was waiting in the wings. And so he ended up using OSHA and the OSHA file in a criminal case. I didn't handle the criminal case, another criminal defense attorney handled it, and he's now in jail. I was able to get him off on the federal side of things, but the local side of things came and really bit him. And so there are all kinds of things you have to consider that may arise, and that's why it's important to take what I'm saying to heart. If you have a relationship with the OSHA area office, you ought to keep that in mind when you're getting ready for OSHA to show up. I mean, if they've had a bad experience with you in the past when it comes to fall protection, for example, you want to try and paint yourself in the best possible light if you can. Hey, last time you saw me, my guys weren't trained. Now I got them all trained. We're all wearing harnesses. However, you need to tailor the inspection to your specific work site, keeping these things in mind. I represent a gun company, and that gun company, for years and years and years, made OSHA go get a warrant every time they showed up. The OSHA compliance officer would be there for a real minor thing, go get a warrant. And guess what? Making them go get a warrant ticks them off. And you turn this little minor inspection item into a 6-month wall-to-wall. And that's what this gun company did every time. And the relationship got so bad at one point, the compliance officer was leaving the facility after one full day of inspecting it and found that his car was saran wrapped shut. The workers there thought it'd be hilarious because that was the attitude they had, you know, screw you, federal government attitude. And then next thing you know, they had U.S. Marshals out at the facility, and things got worse and worse and worse. You know, we all like to tweak the federal government, but we got to live with them. And so I advise folks, look, don't do that. Don't tweak them. You know, give them the appropriate amount of respect, cooperate fully, and make nice if you can. Sometimes you can't. Sometimes you got to stand up for yourself. But the goal here is to get them off your back as soon as you can. Keep your people safe and move on. New reporting requirements, not so new now, but keep in mind that if you've got a fatality, you got to call within 8 hours. There's no getting around that, and it typically falls on the employer who has had the fatality. Things that have changed are amputation, which includes fingertip without bone loss. So that's a little bit less of an issue, but you have to call them. Inpatient hospitalization of one employee, got to call within 24 hours. I had a case a couple weeks ago. I don't know if you guys heard it, down in Massachusetts, where a subcontractor of my client fell and had his fall protection on, but he hung himself by his lanyard. And the subcontractor didn't call OSHA, really didn't call anybody. The ambulance did come, but nobody ever notified OSHA, and so now we have to go deal with the state police, and we have to deal with OSHA and try to figure out what the heck happened. And OSHA does not like it when you don't call them. They're gonna hold it against you, and really hold it against the employer if you don't call. So keep that in mind. Like I said earlier, they're not there to help. They're there to gather violations. We don't want to help them in gathering violations. We want to avoid violations. You've got a set of goals, and that's what I'm showing you here is a set of goals. What are your goals? When OSHA shows up, what are your goals? Well, obviously you want to avoid liability, but you also want to keep the disruption to a minimum because you got a job to do. You got one job, you got to go to the next job, and so you want to minimize the disruption. You want to control the flow of information to OSHA. Now, OSHA is going to interview people. If they're going to interview somebody who's a member of management, that means somebody who's in charge of somebody else, even if they're paid hourly. Make sure you got somebody else in the room when they're being interviewed. I represent a large supermarket chain in the area, and they got hit really hard with, I don't know, $500,000 or $600,000 in OSHA penalties for fall protection issues in their stores, and they got hit with willfuls. And when I dug into the case when I first got involved, what OSHA does is if you've seen them before, they come out, they'll do their inspection, and they write on their notebooks what they found. And then a month or two later, they type up these forms. They're supposed to relate them back to their notes. They type up the forms, and then the forms form the basis of the citations that get issued. And so I said, look, I can't defend my client unless I see your file. They said, okay, Labeau, we'll just give you the typed up forms. And in the typed up form, there was an interview of a high-level member of management on the fall protection issues inside these stores. And it said, yeah, I knew about these fall protection issues. I took them to upper management, and upper management said, no, we're not going to fix it because it costs too much money. I couldn't believe it. That's a damning admission. And I went to the guy and said, Jay, what? Did you say this? You know, I showed him the typed up form. No, I didn't say that. In fact, I never even remember thinking that because it's not even true. So I said, okay, I smell a rat. I need to see the actual handwritten notes from Jay's interview. Lo and behold, he never said that. There was nothing in the handwritten notes that indicated that. But I said to Jay, who else was in the room with you when you were being interviewed by OSHA? And nobody else was in the room. So that's just an example of why you need somebody else in the room. If you're management, so that you can take notes and you can defend yourself if something like that happens. You need, and also, when you're the one that's being interviewed, you're not going to remember all the questions that are being asked and what you said. So it makes sense to have somebody else in the room. You want, as part of your overall goals, is to think about what's bothering the OSHA compliance officer. What is their what's troubling them? Is it a training issue? Is it a personal protective equipment issue? Because the earlier you can identify that problem, the better off you're going to be, hopefully, in heading them off at the pass. And that's what we did with that landscaper up in Maine. Horrible accident, but we had them off at the pass. And they never issued citations. So obviously minimizing liability is also a goal. Again, things you want to consider in advance, you know, is OSHA going to be able to inspect the job site, or are they going to have to obtain a warrant? I will tell you, if you tell them to go get a warrant, you're probably going to be asking for trouble. So, but someone might have to make that call. You know, oftentimes, I would think a lot of NERCA members will be working for somebody else, and you don't necessarily have the power to invite the federal government onto a job site. That's not your call, you know. And if there's nobody else to make that determination, you might have to. Just because you don't have the authority to invite them in, you might have to tell them, well, look, I don't have the authority. You might have to go get a warrant. Who's going to be your contact with OSHA? Who's going to accompany OSHA during the walk-around? Who's going to gather documents? Who's going to arrange for interviews? Usually that's all one person, but figure it out in advance, because that always helps. Because you want to have one point of contact, maybe two, but you have to be coordinated. And you have to be coordinated so that you know what's been asked for and you know what you've given them. Because sometimes they'll ask for 5 things and you only give them 4, not because you didn't have the 5th thing, but because you weren't organized or you had too many people looking into it. And OSHA will say, they're trying to hide something, and then they send a whole team out when you could have dealt with it had you been more organized, better organized. Who's going to make the call if you need to get a lawyer? You know, in the fatality cases, I think you probably need to get a lawyer immediately, because bad things happen when there's a fatality oftentimes, especially if you're the direct employer. And it also helps to, you know, you get counsel involved. You can get in there and say, look, my guys can't talk today. Today's the bad day to talk because this is the day they're coping with the tragedy. Let's circle back in a day or two. And lawyers can typically do that without causing any ill will with OSHA. Now, if the police need to talk with you, you got to talk to the cops. You don't have to, but yeah, you should. Self-explanatory. So your first opportunity to manage the OSHA inspection comes right at the opening conference. You're going to have an opportunity to really set your parameters. You know, you want to find out who the compliance officer is, so make sure they show you their credentials. I've heard, but I've never seen imposters, but there have been imposters out there. You want to make sure you're not dealing with an imposter. And then secondly, you want to know exactly who this person is, because that may dictate how things are going to go. We know of certain compliance officers in Massachusetts and New Hampshire and other places, Rhode Island, who are very difficult, and it's good to know who you're dealing with up front. You want to find out why they're there, and they have to identify the type of inspection. You know, they're there for a complaint. Okay, I want to know what the complaint said. Because you don't want to take them, you know, on a general walk around without knowing the scope. I represented the company that made Twinkies many years ago now, and they had this was down in Wayne, New Jersey, huge facility. They made Suzy Q's and Twinkies and you name it, they made it. And there was this big sugar silo. You know, imagine a silo you see at a farm. Well, this just had powdered sugar in it. It's pretty big. And various lines in the facility, you know, in the factory, you know, the Suzy Q line or the Twinkie line or the cupcake line, they needed sugar from time to time, and they just press a button, and it would go out to the sugar silo. It would meter out sugar and then send it to this pneumatic system, and it would get jammed up. So the maintenance supervisor went out to the sugar silo, didn't fully perform lockout tagout, which means didn't de-energize, didn't shut off all the energy that operated the sugar silo. And when he put his hand up in there, somebody called for sugar, and the metering device turned and cut 2 of his fingers off. So when OSHA showed up at the opening conference, they said, we're just here to see the sugar silo where the accident happened. What should have happened is they should have taken him outside the huge facility, walked him all the way around to the back and then into the silo. They didn't do that. They took him from the front office and walked him through the entire facility, where OSHA racked up what's called plain view violations. If they're in a place that they're legally entitled to be in, which you've invited them in, so they're legally entitled to be there now, and they see a violation, you've just created a larger problem for yourself. So you want to be thinking about, how do I get the compliance officer or officers to what they need to see in a way that's going to minimize the plain view. And that's when you press for a clear understanding of the issues. Then you're going to know where you need to go. Now, protocols. I typically insist that my clients put these types of protocols in their safety manual. I have a whole section on managing an OSHA inspection, and let OSHA know right up front at the opening conference that, hey, we know you're going to ask for documents. They have to be in writing, and they have to go to a particular person. You identify that person, and oftentimes this is done these days. Is done by email. Let the compliance officer know that they can't just walk around by themselves. That they're going to be accompanied at all times by management representatives. And if you're working on a job site with multiple trades, they probably all need to be there. So management reps from all different trades probably need to be there, but certainly you need to be there for your employer. And they're not supposed to conduct lengthy interviews during the walk around because it's too disruptive to the workplace. So just know that something that's going to be more than 5 minutes is unacceptable, and is unacceptable because it's unreasonable. If they want to interview somebody for more than 5 minutes, you're going to arrange that in advance. So you can get a replacement, or you can do it when they're on a break, or when it's not so disruptive to your business. And oftentimes you want to do it when you can get an opportunity to prepare that particular witness for a lengthy interview. And again, I've already said this, but management interviews, you need somebody else in the room taking notes as to what's being asked and what's being answered. You want to let them know that it's your policy that managers or supervisors are not going to sign off on compliance officers' notes. Because, and I've talked about management versus non-management, the reason why management's so important and has to be so careful is because if you're a member of management for a company and you speak, it's as if the company is speaking. So anything a manager says will be what's called imputed to the company. So that's why those statements are very important, and those statements must be protected. And the protocols that help you protect those types of statements are, look, we have a policy that managers and supervisors are not going to sign statements prepared by the compliance officer. We're not going to sign off on the compliance officer's notes. Sorry, we'll give you a full interview, but we can't have it tape recorded or videotaped. At a steel contractor out of Marlborough, Mass. Recently, a couple months ago, we agreed to, the compliance officer was Tom Braille, and we agreed with Mr. Braille that no problem, we'll have all 5 management employees, this is a fatality case, all 5 management employees available on the date that you choose. We mutually convenient date and time to interview, and he showed up and said, okay, Labeau, I'm going to interview these 5 guys, but I'm going to do it all at once. You know, one fell swoop, that kind of thing. And I said, sure, Tom, no problem. You know, it's your inspection, but I'm going to audio tape it. I said, well, no, you're not. That's one of our policies, that we don't allow for audio tape management interviews. And he went crazy. He was very, very unhappy about that. And so he stormed out, and then he came back in and said, we're just going to have to do this the hard way. I'm going to subpoena these guys. And I had to remind his supervisor that, look, you know, this shouldn't be that big of a deal. Your own rule book for inspectors says that if we withhold our consent, then you can't audio tape us. And withholding consent of management interviews is normal protocols, at least in my experience. And I do, you know, maybe 100 of these a year. So we'll see what the verdict is on that. I mean, we've been trying to cooperate. Well, we have been cooperating ever since, but still, you run into some compliance officers who don't like it, but you got to stick to your guns, because otherwise it can really come back to haunt you. I don't know if there would be any industrial hygiene tests in your line of work. There might be, but I don't know if you're ever doing any demo of asbestos or anything like that. But if they do IH testing, they have to give you an opportunity to have your own expert there to do parallel monitoring. If they take a picture, you take a picture. If they take a videotape, hopefully you've got a video camera, or you use your phone to videotape it. Don't let them say, hey, don't worry, I'll give you a copy, you know, later. They never do, unless the case gets into contest. And one of the main goals here is to avoid having to go into contest. You want to, if you do get issued citations, you want to try and settle that at the informal conference, which we'll talk about in a minute. I doubt many NERCA members feel that they have anything that's considered trade secret or business confidential. But I will tell you, think about your contracts, because you don't want your competitors getting your contracts. And so if they're asking for contracts, which they always do, make sure they understand that you consider those contracts to be confidential, and they can't be disclosed to any third party if they receive a Freedom of Information Act request. I'm going to repeat myself here, but just make sure that if you have a big enough crew that requires a walk-around team, that everybody's on the same page. Everybody knows what the rules are. You want to know what the protocols were that were set up, like, hey, walk-around team, remember, if they ask you for a document requests have to be in writing to one person. And so they need to understand all your rights during the inspection. Make sure they understand the idea of the plain view. Make sure they understand the scope. Just understand why they're there. The obvious one is answer questions truthfully and accurately. That's obvious. Of course, you're going to be told by the compliance officer that, hey, man, if you lie to me, that could be a crime, and it is a crime. You can't lie to a federal agent. So that's obvious, okay? But what's not so obvious is telling the truth does not only mean avoid telling a deliberate falsehood. It means, did you see it, taste it, touch it, smell it, hear it? Because if not, then you're probably speculating. And you want to avoid speculating or giving opinions. So fight that. Fight the urge to speculate. Fight the urge to give opinion, because when they write it down in their little book, it becomes fact. And they don't discern between, what you were speculating about and what you weren't speculating about. And I've had many inspection where the compliance officer asks a question and the interviewee answers it, and then the compliance officer just stares at him. And you feel the urge to fill the dead air. Don't do it. Don't do it. If you've answered the question, then you're done. You may get pushed that you're going to admit that a condition or a practice is a violation. That's a legal conclusion. Obviously, if somebody points out an obvious hazard, hey, why is your guy not wearing a harness? Go fix it, right? But admitting that something is a violation, avoid that, because that's a legal conclusion. There has to be a few things that need to be proved, and one of them is knowledge. Did you know, or should you have known, in the exercise of reasonable diligence, that hazard was going to all of a sudden pop up? If the answer is no, then it's not a violation. So that's just an example of how that's a legal conclusion. Like I said earlier, just constantly pay close attention to OSHA's concerns. Figure out what's troubling them early, and you could probably avoid a citation. We have a wind farm. We have a bunch of wind farms up here in New Hampshire, and one in particular is a subsidiary. They were putting this wind farm online. It was a subsidiary of General Electric, and they had two guys getting this one wind turbine up and running, and the senior most guy was inside the wind turbine. These are huge. The base of these things are huge. And the other employee was walking up the steps, and he saw his coworker shaking. And he thought he was joking around until he could smell the burning flesh and realized, oh my God, this guy's locked on. He's being electrocuted. And so he didn't have anything that was insulated. So what he did was he jumped up off the deck and drop kicked him off the equipment. And he hit the ground, hit the deck, and his eyes rolled back and he stopped breathing. And so he performed CPR on him, and by the seventh compression, the guy just snapped to. He woke up and said, "Oh my God, you just saved my life." And he got him out of the wind turbine, and he thought he was going to die, quite frankly. But thankfully, he survived, and in fact, he only lost a piece of his thumb. But that was a long process with OSHA, and they had a lot to work with. And so I was as a chatty Cathy doll with these inspectors, and by the end of the 6 months, we had them off at the pass at every step, on training, on PPE, on everything we could get out of them that they were concerned with. We had an answer, and they ended up not issuing any citations for a near fatality. So that was a victory, and it was a victory that could not have been won without paying close attention to OSHA's concerns throughout the process. Like I said earlier, if someone's going to get document requests or interviews, just make sure everybody's on the same team. If you got a walk-around team, make sure they understand that interviews are scheduled through designated OSHA contact. Documents go through one person. The management statements can be evidence of a violation. Don't guess, avoid admissions, all the things that we've talked about earlier. Plain view, a Twinkie Company example. Again, I don't know how big your crews are, but if you've got somebody, you need to designate somebody as your main contact person, just so you know you got one person that knows what's going on and can coordinate with OSHA, is going to understand what documents have gone out, it's going to understand hopefully what's concerning to OSHA and things like that. So you got one point person conveying the information to OSHA to and from the employer, you're better off. Things don't get lost in translation, and you can stay better organized. I put this slide in here about hazard assessments. I don't know if you're ever going to see this because 1910 may not come across, but they're supposed to ask for hazard assessments. They're supposed to ask for injury and illness records. They will ask you for this. They're supposed to ask you for 3 years worth of records. I always get this question was, hey, Labeau, you said that all document requests have to be in writing, but OSHA is going to come on site and they're going to ask for my injury and illness records. How do I make them put that document request in writing and still show them the records that day? Because they're going to want to see them that day. Typically, you got a 4-hour window to produce those records unless you strike a deal with them otherwise. Here's what you do. You say, look, I got them. Either I've got them or I can get them here within 4 hours. I'll show them to you, but I still need a document request in writing. Okay, so you're going to be able to verify here today that I've got these records. But they'll be considered part of your written document requests, and we'll get them to you in the next day or two. Sometimes they give you longer depending on how long the list of records are that they've asked for. That's why it's important to have your record keeping practices accurate and up to date. Look, I get paid by the 6-minute increment. I'd love to be at every inspection, but the reason you folks are taking this webinar is to avoid having to call lawyers. You should be able, if you follow these rules, you should be able to handle it, a lot of it, yourself. But just keep in mind that if you've got a fatality, you're probably going to have to call a lawyer. And some other folks call lawyers when they've got production methods are implicated, but I doubt that's anything that's going to come up on a NERCA member website or job site. If you get into a tussle with your insurance carrier, that may be a time to have a lawyer come in, but it's the more major inspections or accidents, for example, that it's better to get counsel involved earlier rather than later. Like I said earlier, if OSHA takes a picture, you take a picture, all of that. Don't accept OSHA's offer to provide photos. I had a trenching, one of the larger excavation contractors in the Boston area was up here in New Hampshire, and got hit with a trenching violation. And they're the masters of training and using trench boxes. And so when they came to me, they said, Labeau, no way. The employee, they say, was exposed in the trench. We trained the crap out of him. He knows he's not supposed to be in a trench without a trench box, or without making sure the soils are benched properly, things like that. I said, great, we've got a pretty good defense. So I gave my spiel at the OSHA area office during the informal conference. I said, there's no way we had any knowledge that this guy was going to be in the hole. He was in there for a split second, and so you got to vacate the citation because you can't prove knowledge. And they were smiling at me, and usually they don't do that. And I said, okay, guys, I know you don't normally show me photographs, but it looks like you have some photos you want to show me. And they said, yep, we only want to show you one. And it was this one picture of the employee in the hole waving to the OSHA compliance officer who was taking the picture, but next to him was his foreman. His foreman was also in the hole too. And so now we're screwed because we have knowledge because our foreman's in the hole. And he might have been waving at the camera too. So that was an example of if they take a picture, you take a picture, but in that situation, the foreman who would have taken the picture was actually one of the violators. But and we throw ourselves on the mercy of the court. We got a pretty good settlement out of it. They probably thought it was kind of funny, but you know, don't accept their promise. Hey, you know, you don't need to go back to the job trailer to get your phone or go get your camera because we'll give you copies. They don't normally give you copies, and it's not until later on that they do. I've already talked about IH, parallel monitoring. You're going to know if they ask for a document. You're going to know whether or not it's reasonable. Excuse me. Injury and illness logs, things like that. Just make sure, and you're going to know whether or not a document request is overly broad. I mean, they're not going to be asking for, and they better not be asking for personnel files and things like that. One thing that I've noticed though, they've asked for recently, and they're not supposed to routinely ask for these, which is audit inspection reports. So if, for example, you have contractors risk management, CRM, come around your job site, and you know they do audit inspections to make sure everybody's doing what they're supposed to be doing or correct issues. I've found time and again now that they're asking for those types of audits, and so I'm in an arm wrestling match with Region 1 in Boston. Would you stop routinely asking for these audit reports? Because if you ask for them and you use them against us, we won't do them, and that doesn't help anybody. So I digress. But make sure that the document request is reasonable. Again, there's probably not going to be a whole lot that's trade secret or business confidential, but if there's something in the documents that you're going to give to them that you don't want a third party to see, stamp it confidential, or at the very least, tell them in an email or a cover letter, I consider the documents I'm giving you to be confidential, so they don't make it out on the street through a Freedom of Information Act request. Also, if they've asked for, like I said earlier, an example, they ask for 5 things and you give them 4 things, make sure you tell them that the 5th thing you don't have, or we don't have it, or we couldn't find it, but we'll keep looking, that kind of thing. If it's radio silence about a document they've asked for, they think the worst, and you don't want them thinking the worst. I mean, I like Bates numbering pages of documents you give to them, but that's up to you. Non-supervisory employee interviews. This is where the bulk of OSHA citations come from. Believe it or not, are the interviews with hourly employees. People who don't have a supervisory role. People that are not in charge of anybody else. You know, they're the worker bees. And I will tell you, if you try to insert yourself into those interviews, 9 times out of 10 you're going to cause problems. So don't be surprised if a union rep will be invited into those interviews. They're still considered private if the union rep is in there. But if management tries to get in there, you're not going to make it in. Okay, so what I like to do with hourly employees is non-supervisory employees, I should call them. Make sure that they understand what's going on. Okay, here's what's going on. Here's why you're going to be interviewed. You have the option to say no. You have the option to have somebody with you. You have the option to say no to audio tape. You have the option to say no to videotape. These are all the non-supervisory employees' options. Now, they can say no altogether, and what will happen is they'll be subpoenaed and they will be required to be there. On the upside, if they go that route, they can have somebody in the room when they're subpoenaed. So usually if they understand the process and why they're going in, it's not that big of a deal. What I like to do, though, in major cases, like I had the gun company, again, they had this thing called a proof box. So when you make a firearm, you have to make sure that it's structurally sound. So they put what's called proof rounds in the chamber or in the magazine, and they fire the handgun or the rifle, and the proof round has got like 3 or 4 times more gunpowder in it, so it's got more of a compressive force, and you can tell if the gun falls apart, obviously it's no good. So they put, in this case, they were putting revolvers in a proof box and just shooting them, all 3 shifts a day. And after a while, it built up because there was a problem with the box. It built up, the gunpowder built up, and it ended up catching the guy's face on fire when he opened it up. The air got in there. It hit a pile of unspent gunpowder, and then in essence caught his face on fire. So he got life flighted to the hospital, and so we knew because of that, OSHA was going to come in and interview the people in the room, and the people in the room were all non-supervisory people. So we just said, look, here's for obvious reasons, you're going to get interviewed by OSHA. Let's go over your training. It's just so you know, in the last 12 months, we've done X, Y, and Z training, and you try to remember the types of training that might come up during that kind of an interview. So that's always good. And then afterwards, and we tell them you might be audio taped, videotaped. They might have you sign a statement. You can say no to all that. We try to hear the questions that might come up. And then afterwards we do a debriefing. But make sure that if your hourly non-supervisory employees are going to get interviewed, that they understand that nothing they say is going to be used against them, right? Because you can't fire somebody because they talk to OSHA, that kind of thing. And be wary of, hey, look, I was getting ready to fire this guy anyway, and now he's talked to OSHA. Well, you got to worry about an 11C case. So bottom line, though, is you can't take any adverse actions. You can't fire somebody, cut their pay, cut their time because they cooperated during an OSHA inspection. Because then you'll be asking for a Section 11C case, and what happens is it's a whistleblower case, and what happens is the OSHA lawyers, the solicitor's office, ends up becoming a free lawyer for that employee. So you want to avoid that. So they ought to know, look, this is about telling the truth. Make sure they understand what telling the truth means, and that it doesn't mean just avoid telling a deliberate falsehood, but did you see it, taste it, touch it, smell it, that whole thing. But anything they say, just tell the truth, and it's not gonna come back to haunt you. That's the message. Like I said earlier, management, you're not going to get into the interview 9 times out of 10. Sometimes the compliance officer will let you in. I can't say it's not all the time, but most of the time you're not going to get in. And again, if the union reps are there, it's still a private interview. Like I said before, debrief. Make sure you debrief the hourly employees after they've been interviewed. Because you want to find out, your goal and OSHA's goal is the same thing. We want to keep our people safe. So what OSHA's concerned with, you're concerned with, right? And so that's why you want to talk with your employees immediately after they've been interviewed, so you know what was asked and what was said, and if you have to, you can help avoid any misunderstandings if there were any during the interview. It's also going to help you understand the compliance officer's concerns. Like I said earlier, interviews of management employees, you got to have somebody present during the interview because whatever you say is going to be deemed an admission. And again, I'm repeating myself, but the policies are you're not going to be videotaped, audio taped, that whole thing. You're not required to stage demonstrations. Hey, go get on that lift. Show me how you operate that lift. Whatever. They have the ability to view work as it's being performed. They do not have the ability to make you go do your work so they can see how you do it. They don't have that power. They also don't have the power to shut down your work site. Stop working. They don't have that power. They think they do, some of them, but they don't. Only a U.S. District Court judge has that power. Now, if you go to Cal OSHA, that's a different story, but California OSHA has that power. But that's the only Cal OSHA and U.S. District Courts. Those are it. Okay, stop work. Now, obviously, if you see an unsafe act, correct it immediately. Again, I'm repeating myself, but one of the things that I do, and what we did in the electrocution, almost electrocution case, was once we understood what OSHA's issues were, we bombarded them with documents. You go to the OSHA website. There's a ton to work with there on various topics, and you can say, oh, here's an interpretation letter. Here's a compliance directive. You're barking up the wrong tree. Your own Washington D.C. says you're barking up the wrong tree. That's the benefit of talking them up, because then you can go to their own website and use it against them. I take it back. You educate them. You let them understand what the status of the regulation is. Post-inspection procedures. You're going to be invited to a closing conference. And a closing conference by the regulation means they're done with their inspection. Now, I've heard compliance officers say, oh, this is your closing conference, and they didn't really mean it, but Tom Braille has done that. But that's what it is. It's a time where they're going to say, the compliance officer is going to tell you, this is what we found. And you're probably going to be issued a citation or citations. Do not leave the closing conference without knowing which regulations they're talking about. They're supposed to tell you which regulations they're talking about. They're not going to tell you what the penalties are going to be, and they're not going to tell you whether or not it's a serious, other than serious, willful repeat. They're not going to tell you any of that. That only happens when the citations are issued. But make darn sure that you know what the violations are and try to find out why. This is a time where you can voice defenses, but usually at this point it's not going to do a whole lot of good. You got to be talking with the superiors, and if you're going to give defenses at that point. So you get citations, and then you have the option to attend an informal conference. In the informal conference, I will tell everybody, even if you say, look, I got such a bad relationship with OSHA, or this is a waste of time because I'm not going to settle these things, I always go to the informal, because they can't help themselves but show you things in their file. And I always learn something new or different, usually something that hurts us. And so I want to know that as soon as possible. And that's why I never avoid the opportunity to go to an informal. I try not, unless there's a scheduling conflict. But I try to get to an informal, and if I can't do it in person, I do it on the phone. And I've handled cases across the country, and the ones that are outside New England, I always just do those by the phone, and I'd say 8 times out of 10, maybe 7 times out of 10, we settle these cases at the informal conference. Make sure you set that up within 15 working days of receiving your citation. So you need to make sure you put on your calendar, hey, when did my entity receive the citation, and sign that green card, the certification card. Because that 15 working day deadline, meaning what that means is you don't count the day you received it, you count every weekday, you don't count federal holidays, and you don't count weekends to get to your 15 days. But if you miss that 15-day deadline to file a notice of contest, then you're stuck. So you don't miss that. Put it on your calendar, and you try to schedule the informal conference within that 15 working day period. And that's usually when you try to put on a dog and pony show, is to present all your defenses and try to get the best possible settlement without having to hire a lawyer or having to go down the road with a contest matter, because that can be expensive. Keep in mind, penalties have gone up, everybody. I'm still wondering if they're legal, and I've told folks that they're not legal. And here's why. Let me just tell you why. The bipartisan budget bill permitting OSHA to issue a catch-up adjustment, The problem is the Occupational Safety and Health Act sets the penalties, and the Act, the OSHA Act, was never changed. So the OSHA Act still has 7,000 in it, not 12,675. And so when the regulations conflict with the statute always wins. That's a fight for another day, and the local area offices don't want to hear it, but if you get the right case, you might be able to win it. Partially, the one thing I didn't mention about contests, it's literally a 2 or 3 sentence letter, and make sure you contest the citations, the penalties, and abatement date. You want to get all 3. You want to cover the landscape, because you want to be stuck saying, oh, the abatement deadline, the abatement date's fine, but everything else is not fine. Cover everything when you say I hereby contest. And there's no magic language. I contest or we contest. It doesn't. Just make sure you use the word contest and you cover the landscape on the citations, the penalties, and the abatement date. And that's pretty much it. Now again, if you're prepared in advance, then you're going to avoid a whole heck of a lot of problems. And I'm not sure if I'm trying to figure out how to turn this on if there's any questions.